She shot a woman 4 times, once in the upper lip, and now as a new mother, she's in court asking for a second chance. The defense is about to paint a picture of a woman pushed to her absolute breaking point by relentless harassment and bullying, culminating in a single desperate act of self-preservation. They're arguing for probation, a chance for her to raise her 4-month-old child and continue her schooling. But the prosecution sees it very differently. They see a woman who brought a gun to a nightclub, opened fire in a public parking lot, and came inches away from committing murder. The judge is now faced with a difficult choice. Is this a candidate for rehabilitation or a violent criminal who needs to be taken off the streets? Her entire future and the message sent to the community hangs on this single decision. This isn't just a sentencing, it's a battle of narratives, and the stakes could not be higher.
The defendant entered a plea of guilty to aggravated assault, a second-degree felony, and a pre-sentence report has been prepared. Have the parties had an opportunity?
The defense attorney, Mr. Lewis, is immediately setting a sympathetic tone. His entire strategy hinges on portraying his client, Ashley, not as the aggressor, but as the victim of a long-term campaign of terror. He's talking about people shooting out the windows of her home and constantly taunting her on social media. According to him, the night of the shooting wasn't a random act of violence. It was the final snap after enduring endless torment. He's arguing that this was completely out of character for her. This is a classic defense tactic, reframing the narrative. He wants the judge to see the shooting not in isolation, but as the tragic endpoint of a much longer story of provocation. He's trying to establish a foundation of empathy before he makes his big ask: probation for a crime that could carry a decade in prison.
To review it, and are there any corrections or changes to it?
Judge, I've received it, reviewed it, and we don't have any changes from the judge.
And state.
Same, Your Honor.
All right, it will be made part of the record for all purposes. And the agreement here is a cap of 10 years imprisonment. So we are looking at two options on the second-degree felony. No less than 2 nor more than 10 years confinement in prison. Also, the defendant could be placed on deferred or unadjudicated probation.
Yes,
I don't believe regular probation
is
an option under law because of the circumstances of this case. All right. Mr. Lewis, you may go forward.
Judge, this situation, fortunately, it wasn't worse than what it was. Definitely. But it was a situation where my client has been dealing with some harassment and bullying, dealing with the complaining, her friends for a long time at this period. This confrontation here is pretty much her breaking point at that moment. It was totally out of character for her. Not something that, in normal regular circumstances, she would have acted in that way in any way. It was a situation where, and when I say prior bullying and harassing information, I'm talking about from people coming, breaking or shooting in the windows at her home to, very severe or serious circumstances, is that these things have been going on, and actually have been even still dealing with some of it after this case happened, while she's been on bond, to the point of people associated with the complainant or either screen recording or whatever, sometimes docket, and would post these things on social media in an effort to taunt her while this case has been going on. And there was even a situation where she's had people try to confront her. Now, I will say my client and her actions since then, she's done everything she can on her end to try to avoid these situations at all costs. She had moved to a new location that is a safe place for her and her child, that's undisclosed as far as she knows, as far as people associated with the complainant. She has been haven't had any issues while she's on bond as far as attending court or doing anything of that nature, other than, I believe, she had one situation where when she was in the hospital having a child, she had to miss court, but they had medical issues at that time. She has a 4-month-old child this time to raise and take care of. And as you see in the PSI, she has, until the pregnancy, maintained a stable work history, as well as going to school to help try to further her career. So she is making positive changes for herself, or I won't even say changes, staying on that same track. So I believe her future is one that's definitely salvageable in this circumstance. I think there's plenty of vehicles available through the probation department that could help Ms. Money as far as move forward, as well as still be able to um, serve out any punishment or sentence that court deems necessary. There, I know there's restitution involved in this case that my client through with her school.
After her attorney lays the groundwork, the defendant, Ashley Mooney, addresses the judge directly. She starts by saying she takes full accountability, a phrase judges often want to hear. She emphasizes how much her life has changed, highlighting her new baby and her enrollment in school, classic signs of a life turned around. However, watch the judge's reaction closely. He immediately cuts in to ask if she was a mother at the time of the offense. The answer is no. This is a subtle but critical move by the judge. He's establishing that the positive life changes she's talking about all happened after she committed a violent felony. He's preventing her from using her current status as a new mother to retroactively justify or excuse her actions on the night of the shooting.
And her career moving forward, I think she'll be able to take care of that and do what she can to make the plaintiff whole in that circumstance. There are other conditions, of course, that's available to the court, as well as county jail time or anything of that nature to satisfy any concern the court may have of her actually serving some time in jail if necessary. And I know as far as her version of everything, she talks about.
This is the moment the defendant's story begins to unravel under scrutiny. The judge asks her to explain how she was in fear for her life when she was the only one with a gun and the only one doing the shooting. She claims the victim tried to run her over with a car. This is the cornerstone of her defense, that she was protecting herself. But the judge is a veteran of these narratives, and he's not just taking her word for it. He immediately pivots to the official police investigation. He's asking a simple, logical question. If you were the one being attacked with a deadly weapon, a car, why weren't the other people arrested or charged? He's laying a logic trap, and she's walking right into it.
Concerning the car running her over or running them over, if the evidence doesn't totally support that, but of course, what she may have been thinking of going through some of her friends, at that time could have been it, but maybe not enough to rise to the self-defense claim that she could have maybe used that trial, liable to use that trial. So we are asking that the court seriously consider placing her on deferred adjudication. I think she's the type of candidate that will be able to make the most of that circumstance and be able to be successful and move forward. Also, I would like to, she did want me to let people know she wanted the opportunity to address the court and let you know how she would, her plans for the future, as well as her being able to be, how she feels for it being able to be successful on the deferred judge.
Yeah.
I just want to let the court know that I take full accountability of what happened today. And I am very I changed my life all the way around. I don't hang around the same people. I have a child now. I'm in school and everything around me is positive now.
Did you have a child then on March 30th?
Yeah.
You didn't have any? Were you pregnant then?
No, I got pregnant after.
Okay, go ahead.
And it was out in a kind of a hard situation, but I take full accountability of everything that happened that day. I wish everything was different. And I wish I could take it back, but it's you can't take it back. It happened. And I take accountability of what happened.
What caused you to act this way?
I want to say I was just at a breaking point, really, to the point where it was so much that happened to me, with these people.
The judge now completely dismantles her self-defense claim. He points out the glaring inconsistency. She claims she was the victim, yet the police investigation resulted only in charges against her. Then he delivers a stunning correction. The defendant had admitted to shooting the victim 3 times, but the judge Reading from the official report clarifies it was actually 4 times, listing the wounds shoulder blade, ankle, forearm, and upper lip. 853, 857. This detail is devastating. It transforms the narrative from a potential panic shooting to a sustained violent assault. The judge makes it clear that from the court's perspective, this wasn't self-defense. This was her losing her composure and opening fire. He's essentially telling her that her story doesn't add up with the evidence.
So it's like a breaking point thing. And I was kind of in the fear of my life, and they probably was in the fear of their life as well too.
How were you in the fear of your life? Can you explain that? Because only one person was shot more than once, right?
At the time,
And it was you doing the shooting.
when it was going on, like before the shooting happened, she was kind of in her vehicle trying to run me over. Like it was like a thing like that. So I was like, basically not like defending myself, but at the same time trying to protect myself and who I was with. And basically, I guess she was trying to protect herself from who she was with.
Okay. The police came out and investigated this, didn't they?
Basically.
Okay. Uh, so after their investigation, did they charge the other people with attempting to harm you in some way, attempting to kill you, or attempting to assault you with their car? No?
Mother charge.
Does that no?
No.
You have to speak out. So
No, sir.
why do you think that? Or did the police fail in their job, or do you think they investigated this thoroughly?
In my opinion,
Mm-hmm.
I really don't think that it was because when they called me, I was actually I was out of town when they called me. But I told them when I came, like when I was coming back, and they were supposed to came out and like fully investigate with me to take my side on what happened that day, and they didn't.
Well, they investigated it and they did not elect to file charges against the other people who you say were attempting to harm or kill you with a car.
Correct.
And you were defending yourself. Self-defense. That's what it seems that you're saying here. You're not admitting, you're saying that they were trying to harm you and you were defending yourself by.
The judge is now directly challenging the defense's strategy. He praises the defendant's lawyer, Mr. Lewis, calling him a wise man who knows how to evaluate a case. 1044. This is a strategic move. He's saying that if there was any real substantial evidence to support a self-defense claim, if the car attack story was anything more than a story, her skilled attorney would have taken the case to trial. 1052, by pleading guilty, she and her lawyer have already conceded that they couldn't prove self-defense to a jury. He then lays out the hard truth of the law. Threats and provocations are not a legal justification for pulling a gun and shooting someone 4 times. 1032. He's essentially saying you were dragged down to their level and then you escalated it to a degree the law cannot forgive.
Protecting yourself with a firearm and shot somebody 3 times, right?
Yes, sir.
The right shoulder blade, left ankle, left forearm, and upper lip. Sorry, 4 times. But upon their investigation of this, they did not charge the other people with anything victimizing you, just you.
Correct.
Which this leads anybody reading this to believe, according to their investigation, you just lost your composure and decided to use a file, which was the wrong thing to do. Well, you got to pay a price. Okay, well, too many people come in here and this always somebody else's fault, and you're taking responsibility for your actions.
Correct.
But you have a lot to lose here. This could have been up to 20 years in prison. You understand that? And you got a family, a child,
Right.
and that you got to take care of, and a family that's, I guess, you're growing.
Yes.
And and you don't have a criminal history.
No.
Look, this isn't the first time somebody is before this court charged with a serious crime who believed that a lot of it had to do with being provoked. But yet, words, threats, those things are just under the law aren't enough to get in a car, get in a gun and shoot somebody 4 times. And the situation about you were defending yourself, truly, Mr. Lewis is a very wise man and he evaluates cases. And if he felt like there was something really to substantiate that, he would, we would be having a trial like we have 600 trials in this court. I mean, we try cases and we're not afraid to try cases to get the facts out, get the truth, get responsibility.
Just when you think the defendant's chances couldn't get any worse, the prosecutor stands up and brings the voice of the victim, Miss Ford, into the courtroom, and it is a voice filled with rage. The prosecutor reveals that the victim is adamantly opposed to probation and in fact wanted the maximum possible sentence, 1341, 1356. She's so angry about the plea deal that she's been sending furious emails to the prosecutor's chief. This shatters the defense's narrative of a situation that might have had mutual fault. We now have a clear victim who feels the justice system is failing her. The prosecutor also highlights a bizarre and suspicious detail from the pre-sentence report. Both the victim and law enforcement were supposedly unsuccessful to contact for their input, something the judge says he has never seen.
Placed on the people who have, who justly deserve the responsibility. And this is one of those things where I believe we have a misunderstanding, to say the least. But you got to have the strength of character just to move on and be the better person. Because what happened is at the worst, at the best for you, is they dragged you down to their level, and then you pulled a gun, and then you get in trouble. And but once again, nothing shows that there's nothing here that reflects you had to use that firearm to defend yourself. You were in imminent danger of death or serious bodily injury from being run over by a car. Nothing shows that. And if it were, we'd be here trying this case, and that would be a defense. But you accepted responsibility under these terms.
The prosecutor now delivers a series of devastating blows to the defense's case. First, he reveals that he personally investigated the defendant's claims of bullying and harassment, and he found no merit in it. 1652. This completely guts the defense's core argument that she was a long-suffering victim. Second, he paints a vivid picture of the crime scene, a shooting at 1:30 in the morning outside a notorious nightclub, a place known for criminal activity. 1741, 1754. This wasn't an innocent person caught in a bad situation. This was a violent encounter in a high-risk environment. He tells the judge that he has personally seen the victim's injuries and that this case was merely inches or seconds away from dealing with a murder case. 1606. He is making it clear that probation is not just inappropriate, but an insult to the severity of the crime.
This set of circumstances, and there are no objections in this pre-sentence report?
No, sir.
Okay, and it's made a part of the record for all purposes. What says the state?
Judge, I do note one error in the PSI. When you look underneath the adult felony court history, the deadly conduct, which I am dismissing as part of this plea agreement, comes from the same date and offense. For some reason, there's a different date there, so that needs to be corrected to where it's March 30th of 2024.
Okay, so it was this other charge arose, I guess this is 24 CR 1105.
Right,
this arose from the same episode?
Yes, sir.
So the agreement is that indictment is going to be, which is a third-degree felony of deadly conduct, discharge of a firearm, that is going to be
It'll be dismissed, but that should be corrected for the purposes of the PSI and this particular clause number, Judge.
Okay.
All right, so second matter. I'm really shocked that no statements come from Miss Ford, the victim in this matter. I've had constant contact with her since the beginning of this case. She is adamantly opposed to Miss Moaning receiving probation. That is a discussion that Mr. Lewis and I had while we were negotiating the resolution of this matter. Of course, what she wants is the maximum, and she's in opposition with me about the plea bargain agreement that was made. She's made that very vocal to our office, including my chief and emails and things of that nature, which is why I'm really shocked that that there aren't statements.
The defense attorney makes one last plea for mercy. He insists that his client truly does take responsibility and that she's a different person now with a child to live for. He's trying to pull the focus back to her potential for rehabilitation, arguing that the person standing before the court today is not the same person who pulled the trigger that night. He frames it as a choice between punishment and progress, pushing for deferred adjudication as the path that allows her to become a productive member of society while still serving her debt. It's a final desperate attempt to convince the judge to look at the person she could be rather than the person she was on that single violent night. Do you think he's convinced the judge? Let us know your prediction in the comments.
From her, and B, that she may not be present here today. That being said,
Okay, in the pre-sentence report that's been placed into evidence on that point, so the
Yes.
record is clear. Statements of interested persons and the probation office is I always want as much information to make an informed choice. This states, all attempts to contact the victim in this case have been unsuccessful. Any correspondence received prior to sentencing will be forwarded to the court as a memo, which it was not done. All attempts to contact law enforcement have been unsuccessful.
yeah, I don't know
I've
whatever.
never seen that. This is odd. I've never seen a lack of response to the probation's office requests for information, but without it, this court, I know what you're saying about what the victim says, but when given an opportunity here where it needs to be, so the court can consider it, they refuse to talk.
So I'll be her voice because I do know what she has expressed to me. She is overwhelmingly disappointed in how this matter has been handled by law enforcement. She is adamant that Ms. Moaning not receive probation. She and I have visibly seen the injuries that she suffered. The PSI is correct that they are serious bodily injuries. It's very difficult for her to even travel. She is a Houston resident, and the timeframes that we've been able to meet, it's quite a struggle for Ms. Ford to even accomplish that. To say that when we deal with aggravated assaults with a deadly weapon, that we are merely inches or seconds away from dealing with a murder case. I saw that when I saw the injuries that were apparent with Ms. Ford. So with that in mind, Judge, disappointed with the defendant's version, but Your Honor has already gone into the detail about that, so I won't highlight that. I will say that her lawyer isn't.
The judge is now making his thought process clear, and he's focusing on the sheer recklessness of the defendant's actions. He lands on a critical, undisputed fact. She brought a gun into a club that sells liquor. This is a monumental error in judgment that precedes the shooting itself. He points out that by being armed in that environment, she set the stage for tragedy. He then broadens the scope beyond the intended victim, emphasizing the danger to the public. He calls out the wild shots that could have hit anyone in the crowded parking lot, turning this from a personal dispute into a public menace. He's no longer just talking to the defendant. He's thinking about the standard he needs to set to deter this kind of behavior in the community.
Excellent advocate. He has been working on this case throughout. Mr. Lewis brought to me, we're always on a first name basis, so I'll be professional and say Mr. Lewis brought me the arguments about the bullying. He brought me the evidence that he was tendered. I investigated those claims. I found no merit in it. Otherwise, you would see something different. It was only due to his advocacy that I capped the agreement at this to allow him to come into court to make the best argument for his client as far as the probation is concerned. But as I said, I'm disappointed with how she approaches this. She tries to appear as the victim, tries to minimize the situation here that was done. And it is not a situation that anybody in Beaumont would be proud about. The situation that occurs is a shooting that happens in the heart of the West End, right across from Parkdale Mall. at a time in which most people, much like a case we dealt with earlier in this courtroom, judge, are at home and asleep. 1:30 in the morning, right outside of Fuma, Dubai, just like she describes, this is more of a nightclub than anything else. And the criminal activity that takes place here with the amount of shootings and the injury that takes place is alarming to me. And that highlights what the probation office says, which is, as the defendant appeared to take responsibility for actions occurring that night, the violence that was inflicted upon the victim.
The tension in the courtroom suddenly boils over. As the judge is speaking, there's an audible reaction from the gallery, likely family or friends of the defendant. The judge immediately stops his sentencing and puts the entire room on notice. He warns that anyone who makes a sound will be held in contempt of court and sentenced to 180 days in jail. This is a raw display of judicial authority. The emotional weight of the moment has become so heavy that it's spilling out into the audience, and the judge has to slam the brakes to maintain order. It's a stark reminder that his decision will have a profound real-world impact on many people's lives, and the pressure in the room is at its absolute peak.
And the community is alarming. The defendant appeared to not take into consideration during the offense how innocent bystanders could have been harmed or killed from her actions. That's why the other
You said
case
the
was
victim,
filed.
the defendant.
I apologize. You're correct. The defendant appeared to not take into consideration during the offense how innocent bystanders could have been harmed or killed. Judge, these are the kind of things that with the DA's office, when guns are involved, shootings occur, and near death almost happens, we cannot agree to probation. I can appreciate that she's never been in trouble before, but I don't think she appreciates that we almost lost someone due to her actions. Stand by the cap that was offered. I suggest 10 years.
Go ahead. Anything further, Mr. Lewis?
Well, Judge, just one thing I would like to add is that in Ms. Moni's statement to the court, you know, main reason she wanted even to do that was to make sure you understood that she was taking.
The judge delivers the final, devastating analysis. He states that when you shoot someone 4 times, there is only one purpose: to kill them. 2625. He dismisses any notion that this was an attempt to wing or warn the victim, especially given that one of the shots was to the mouth area. 2638. He bluntly tells the defendant she is lucky this is not a life imprisonment case. Then he directly connects her actions to her plea for a free ride on probation, stating that the sheer irresponsibility of opening fire in a public place cannot go unpunished. 2452. He credits her attorney for negotiating the maximum possible sentence down to 10 years, but it's clear from his tone that a sentence of pure probation is completely off the table. The only question left is how many years she will serve.
Full responsibility for her actions. In no way she's trying to minimize what happened out there. She doesn't understand how severe that circumstance was. And that doesn't change my opinion that if given the opportunity, I believe she could definitely be successful on probation, especially with the track she was on.
The sentence is delivered. The judge finds Ashley Mooney guilty of aggravated assault with a deadly weapon. Rejecting her plea for probation and the prosecutor's request for 10 years, he lands on a sentence of 4 years in the state penitentiary. 2752. He makes it clear that the judgment will reflect that a deadly weapon was used, which will have implications for any potential parole. As the sentence is read, the gravity of the situation finally hits. The defendant, who walked in hoping to go home to her child, is now facing years behind bars. The judge gives one final lecture, telling her and everyone else that wiser choices must be made when firearms are involved, reiterating that there was zero evidence to support her self-defense claim.
Already on and what she could continue to do, especially in raising her child. You know, this moment, especially now, is totally different where she has someone else, even beside herself, to totally live for and make decisions for. So I still stand by that and ask that the court consider deferred in the situation.
All right. Some circumstances are a lot more difficult than others that the court has to deal with, and this is an agreement, but it still gives the court options on how to proceed. Among other things, the court tries to set a standard on similar behavior, how people are going to be dealing with similar behavior upon rulings of the court when they are put in a situation they may not be paying attention, but the ones who do go, somebody got in trouble and went to prison for this not long ago. I better not do this. If they're able to think coherently during the time. And nothing, if it were true that the defendant was committing, was defending herself under the law, that should have been raised in a different setting, but it was not. It wasn't. And there are ways of dealing with self-defense as a defense, and it's not supported here. It does state, it doesn't say that, except for you, that somebody was trying to hit you with a vehicle and you were shooting to defend yourself from a vehicle that was being driven at you when you were just walking across the parking lot innocently. That's not in here. That's what you're saying, but it's not in this pre-sentence report that was prepared and is what the court can consider. What we do know is that this was a product of something that had earlier occurred that should have been dropped. It was something had happened before, and as they were leaving, and as the parties were leaving the club at 1:33 in the morning, where nothing really good happens, then you are shooting at this vehicle and the people in the vehicle, and somebody shot 4 times. Not just for that purpose, but this is a public place, and there are probably other cars, and you're lucky 3 or 4 people didn't get shot by wild shots. It's just you can't handle issues like this in a way that is irresponsible. And what are you doing? Well, this was a club, right?
Yes, sir.
What are you doing it sells liquor?
Yes.
What are you doing in there with a gun? What are you doing in there with a firearm anyway? That shouldn't even be in there. This was very poor choices, and you're lucky that this person who was shot 4 times in the shoulder, left ankle, forearm, and upper lip, I don't know how that happened, that they weren't seriously injured. And others in the parking lot weren't injured. I mean, several people could have been harmed. We've got to, by our decisions and what goes on in this court, set standard for everyone. This, Mr. Lewis is asking for probation, and it's an option in this particular situation, but it's these are circumstances that this court has a lot of problems with in believing that probation and deferred or unadjudicated probation in this case is the way to go. I mean, it was multiple shots fired, and this why just God's will is, I mean, you were intending to shoot this person. God's will prevented a murder from happening where you would be looking at up to life in prison. And messages have to be sent. You can't just go into a shooting spree in a public place and people also get harmed and people are in harm's way. And that's you're going to get a free ride out of that, and as it were, and get probation. I mean, it's just all irresponsible from the beginning to the end on this. And the difficult thing is that you got a family at home that needs you, and the district attorney's office is asking for 10 years in prison. And if I hear a response, anybody that responds while the court is talking will be held in contempt of court. I don't want that. That's 180 days in jail. Anybody want to say anything? The peace, be quiet. We're conducting business, or leave if you want to. You have freedom of speech. Go outside and speak, but don't interrupt this court. I can hear that. We all hear that. And she's taking this down, and what she hears as the court reporter, she takes down. And statements from the crowd don't count. Please follow the rules. Thank you. Um, the court has to set an example. This is highly irresponsible. You shouldn't have had a firearm in the first place at that location. Anyway, I mean, that's prevents you from losing your composure, which I think it's obvious you did. But when you shoot somebody 4 times, there's only one purpose, and that's to kill somebody. I mean, you don't shoot somebody 4 times and think, oh, I'm just going to wing them. That's not it. And one of them is a shot in the mouth as well. You're lucky. This is not a life imprisonment case. All right. Your attorney has minimized it to 10 years and up to 10 years in prison. What this court is going to do is these are more difficult. Some decisions up here are far more difficult than others, and this is one of those. The court is going to find that you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. And the judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this crime. Do you understand what has happened today, May? All right. You and others must make wiser choices when there's a firearm and there is a situation where people can lose their composure. You're lucky that it wasn't a murder case, but you can't be firing a weapon numerous times at a public place and not be held responsible. And there's nothing here that supports anything in this report, nothing that shows you were acting in self-defense or that there was a need for it. That's the order of the court. This other case is
I've sent the dismissal.
dismissed. Thank you. That is all. I need a pen. This. Yeah.
On his mom's case, now I believe is outside, is it anywhere in ready land so she can see if she leave.
Yeah, you got to talk to the bailiff.
Okay, okay.
Please.
Just so she can.
Go
leave
in.
the house. Okay.
Go in.
4 years in prison. In the end, the judge split the difference between the 10 years the prosecutor wanted and the probation the defendant begged for. He acknowledged her lack of a prior criminal record and her new responsibilities as a mother, but he could not overlook the sheer violence of the act. 4 shots fired in a public place, an act he called a near murder. Her claims of being a victim of bullying were dismissed, and her story of self-defense crumbled under the simple logic that the police only charged her. The final scene of her being taken into custody is a sobering reminder that actions have severe life-altering consequences. Was 4 years a just sentence for this crime? Should she have gotten more, or did the judge get it right? Let us know what you think in the comments below, and make sure to subscribe for more in-depth courtroom analysis.